Liability of network service providers under the Information Technology Act, Part 3 continues. A small number of courts have held that the act of providing internet service attaches liability to an ISP for copyright infringement. These seemingly harsh decisions are due to the fact that in response to subscriber requests, NSPs reproduce and distribute copyrighted material, as every download causes the NSP's computer to copy the material and forward it to the subscriber. Copyright law aims to balance the competing policy goals of encouraging creativity and allowing public access to information. This balance is particularly important and difficult when it concerns the internet, where meaningful copyright protection must exist in order to promote further intellectual development in the internet, and failing to provide protection would lead to a reduction in the incentive to create and less material available for public use. Therefore, it is important that copyright owners are protected and compensated for infringements occurring over the internet. The rapid expansion of the internet, however, greatly expanded the context in which copyright infringement can occur. The internet, with its inexpensive access, quick downloads, and forwarding capabilities, allow users to effortlessly bypass copyright laws at a substantial cost to legitimate users. As the internet expanded, law remained static and increasingly became incapable of handling such situations. Traditional protections such as cease and desist orders and court action prove ineffective, as letters are ignored and the litigation costs outweigh recovery in most cases. Moreover, as users can easily post information anonymously, even locating the alleged offender proves difficult in many cases. No longer protected, copyright holders attempted to hold internet service providers, that is ISPs, liable for subscriber infringements. 4.2 Vicarious liability. Although the Copyright Act does not explicitly recognize vicarious liability, American courts generally impose vicarious liability when the defendant has the right and ability to supervise the offender and a direct financial interest in the exploitation of copyrighted materials. Therefore, NSPs could potentially be vicariously liable, since the NSP has a close relationship to the subscriber, owns the equipment that transmits the material, and could financially benefit from the infringement. Courts hesitate to find ISPs vicariously liable, however, due to the fact that NSPs have little control over subscribers, and the fact that subscriber actions do not directly affect NSP profitability, provided the NSP gets a flat fee for service. The above does not provide absolute protection for NSPs. However, as the majority of district courts in America have not ruled on the issue, and some may be inclined to find the NSP vicariously liable if it could be construed that they receive benefit from the infringing activity. The likelihood of a court today finding an NSP vicariously liable for subscriber infringements of copyright is minimal. Instead, most courts are likely to find that the NSP does not possess the needed level of finances or resources to have the ability to supervise and control subscriber activity, and that when paid a flat fee for service does not have the direct financial interest needed for liability to attach. In addition to granting exclusive rights over the creative works, the Copyright Act grants copyright owners with the exclusive right to authorize the exercise of those rights. The authorization right is explicitly mentioned in the Act to avoid any question of contributory infringement for those who do not infringe the copyright themselves, but authorize others to do so. Although the Act does not mention contributory infringement, courts have read the provision similarly and considered whether an ISP can be liable for providing services and equipment to the infringer. 4.3 Contributory liability. Contributory liability is the most likely way in which courts will continue to find NSPs liable for subscriber infringement. Contributory liability requires the NSP to have actual knowledge or strong evidence of or materially contribute to the infringing conduct of another. For contributory negligence to attach, courts have held the NSP must have substantially participated in the infringement. Therefore, simply getting a service or good that will be used to infringe is insufficient for contributory liability. Courts differ on when an NSP must remove material or face liability, sometimes resulting in cases where NSPs permit actual infringement. For instance, Netcom holds that NSPs are not liable for contributory negligence unless the subscriber has no plausible claim of non-infringement and the NSP substantially participates in the infringement. 5. How can an NSP qualify for exemption from liability for copyright infringement? To qualify for exemption, NSPs may neither initiate the transmission, select the receiver, nor have any editorial control by selecting or modifying the material. Section 79 of the IT Act also provides two circumstances under which an NSP can qualify for exemption from liability. 1. Lack of knowledge, and 2. Exercise of due diligence. 5.1 Lack of knowledge. Knowledge of the illegal contents on part of the NSP is a prerequisite for holding him liable under Section 79 of the IT Act 2000. The NSP can escape liability if it could be proved that he was unaware of all that was stored and passing through his servers. But if he is put under a notice that some infringing material is either stored or passing through his servers, he has to take proper action for removing or disabling that material. Otherwise, he could be said to have knowledge of the infringing material and held liable. 5.2